On appeal, the Supreme Court of Arizona held that Miranda's constitutional rights were not violated in obtaining the confession. The court ruled 7-2 that a right to privacy under the Due Process Clause of the 14th Amendment extended to a woman's decision to have an abortion. In a 5-4 decision, the court held that Johnson's burning of a flag was protected expression under the First Amendment. In a 6-3 opinion delivered by Justice John Paul Stevens, the court held that executions of mentally retarded criminals are cruel and unusual punishments prohibited by the Eighth Amendment. In a 5-4 opinion, the court ruled that standards of decency have evolved so that executed minors is cruel and unusual punishment prohibited by the Eighth Amendment. In a 7-2 decision, the court held that the Sixth Amendment guarantee of trial by jury in criminal cases was fundamental to the American scheme of justice, and that the states were obligated under the 14th Amendment to provide such trials. In a 5-4 decision, the court held that government involvement in this case creates a state-sponsored and state-directed religious exercise in a public school. Such conduct conflicts with settled rules prescribing prayer for students. In a 6-3 opinion, the court reversed the Fifth Circuit and held that Miller had no right to privacy in his bank records. The exclusionary rule of the Fourth Amendment applies to searches and seizures conducted by school officials in public schools. In a 5-4 decision, the court held that the Second Amendment protects an individual's right to possess a firearm unconnected with service in a militia and to use that firearm for traditionally lawful purposes such as self-defense within the home. Coercive drug testing imposed by school district upon students who participate in extracurricular activities does not violate the Fourth Amendment. The First Amendment's protection of the press freedom does not give a reportorial privilege in court. The court held that the Sixth Amendment's guarantee of counsel is a fundamental right essential to a fair trial. Cruel and unusual punishment does not apply to corporal punishment if the state allows it. Neither the prayer's non-dimensional character or its voluntary character saves it from unconstitutionality. Schools could not ban kids from wearing armbands for protest. The court found that the relationship among the club's members was not of the intimate or private variety which warrants First Amendment protection. The High Court said evidence seized unlawfully without a search warrant could not be used in criminal prosecutions in state courts. Any manual recount of votes seeking to meet the December 12th safe harbor deadline would be unconstitutional. The Fourth Amendment does not prohibit the warrantless search and seizure of waste left for collection outside the curtilage of a home. California Court of Appeal reversed. The Sixth Amendment protects the right to effective assistance of counsel. In the case of high school athletes who are under state supervision during school hours, they are subject to greater control over than over free adults. The court held that the First Amendment protects the publication of all statements, even false ones. Segregation of students in public schools violates the Equal Protection Clause of the 14th Amendment. The sentence of death for the crime of rape is grossly disproportionate and excessive punishment. The majority held that under the First Amendment, corporate funding of independent political broadcasts in candidate elections cannot be limited. The court held that distinctions drawn according to race were generally odious to a free people and were subject to the most rigid scrutiny under the Equal Protection Clause. Defendants' criticism of the draft was not protected by the First Amendment because it created a clear and present danger to the enlistment. There is no constitutional right to a unanimous jury verdict in criminal cases. Possession of a handgun near a school is not an economic activity that has a substantial effect on interstate commerce.